Before I read the little bits I need to, for the Hansard record, can I ask each of you to please state your full names and the capacities in which you appear today?
Certainly. It's Rami Greth, Executive General Manager of Enforcement at the ACCC.
And Nicholas Hees, Deputy General Manager Enforcement at the ACCC.
Thank you. I remind senators that the Senate's resolved that an officer of the Department of the Commonwealth or state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. Clause prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about how they were adopted. If you have a claim, any claim that it would be contrary to the public interest to answer a question must be made by a minister and should be accompanied by a statement setting out the claim. I'd now like to invite you to make a short opening statement, and at the conclusion of that, committee members will be able to ask questions. Did you have an opening statement?
Thanks, Chair. No, look, we're just happy to assist the committee in any way possible, so we'll be happy to go straight to questions.
Thank you. Senator McGrath, would you like to kick off?
Yeah, thank you. Yes, thank you. So I understand you have a complaint before you in relation to the withdrawal from or the retirement of the Holden brand by General Motors. Are you able to give just a general update as to where the assessment of that complaint is at, please?
Certainly, Senator. It's Rami Greth speaking. So we're in the middle of an investigation at the moment, looking into issues or allegations of unconscionable conduct and misleading and deceptive conduct levelled against General Motors Holden. So we are assessing evidence, assessing the complaints to see whether or not there is a matter that's actionable under the Competition and Consumer Act and the Australian Consumer Law.
You touch upon this in your submission, and one of the issues that we've faced through the inquiry with speaking to dealers privately, especially when speaking to dealers privately, is the reluctance and reticence of dealers to go on the record. And we had an exception to that, which was the dealer from Mr. Palmer from Inverell. Is this impacting or impacting on your inquiry? Because my observation is that the fear that is felt by the dealers is a serious fear, and it comes from decades of experience of dealing with the manufacturers. Is that something that you're able to try and address in terms of achieving an acceptable amount of evidence from dealers?
Yes, Senator, I can say that it's not unusual when dealing with investigations into conduct by franchisors or by large corporations generally that franchisees or suppliers to those organisations are often concerned or reluctant to go on the record and provide evidence that might require them to be named and come forward as witnesses, for example. So I can say this case is, not unusual in that regard. But what we find in matters such as this is that there are a range of parties. There are parties who don't want to go on the record but are willing to provide information that might assist our inquiries, and then there are those who are willing to also go on the record. So we face these issues time and time again when dealing with situations such as this, and this is no different. Hopefully that helps. I should say, of course, that I don't want to underestimate the challenges that causes us when it comes to bringing proceedings, when there is that perception of fear or repercussions that witnesses might believe they will experience, and it's a very difficult challenge to overcome as a regulator and enforcer.
My understanding is it was on your initiative that there was to be mediation between General Motors Holden and the Holden dealers. Why did you suggest mediation as a course of action?
Well, Senator, I just need to correct your understanding. The ACCC didn't suggest mediation.
Okay.
Mediation was an option available to the parties under the franchising code and the dealer agreement.
Okay, thank you.
We simply ensured that or sought that Holden engage in that process in good faith. That was our aim, was to have them engage in a process to which the dealers were entitled to trigger. Okay.
And you may not be able to comment on this, but what would the difference be between requiring fairness or preventing unconscionable conduct in terms of achieving sort of effectiveness of regulation? Is it your view that the proof of unconscionable conduct is too difficult to regulate sometimes, given case law?
I think that's a fair summary of the ACCC's position, that the legislative bar, as determined by the court for unconscionable conduct, is quite high, and as a result of that, the ACCC believes there needs to be an unfair practices standard that may assist in bringing about outcomes for consumers and business that doesn't require the high bar that unconscionability has been held to.
Okay. I think I might have a couple more questions, but I'll hand back to you, Senator Pratt.
Thank you, Senator Farrell.
Thank you, Chair. I've got a few questions on the impacts on customers and dealers out of what's happened here. My first question relates to whether or not 10 years is a reasonable time frame for Holden to guarantee servicing and parts for its Australian customers.
I think the ACCC has held that it may not be sufficient, but I guess the determination of what would be considered sufficient would be something to be assessed in the particular circumstances at the time. So it's something we intend to monitor, of course, and also note that Holden's statement would indicated that it would be at least 10 years. But we're certainly, the ACCC certainly of the view that 10 years may not be sufficient, but it's hard to be any more specific than that at this point in time. But it's certainly something we'll be looking closely at.
So you don't have a figure on what you think might be a more reasonable timeframe at this stage?
No, not at this stage. As I say, the determination of the question of providing repair facilities and spare parts is a contextual one, and so it's hard to be definitive. I guess this far out, if we know that it's at least 10 years, that's good. But you know, we don't see a bright line where all of a sudden it's clear that the obligation has been removed. So,
Senator
sorry,
Farrell, do you mind if I ask a follow-up to that? I can understand why you need to look at that in the context of what's actually happening in 10 years' time, but Holden will be much less of an entity here for which the Australian government and Parliament is able to extract that accountability for those future consumer issues. How do we foresee those issues? What can we do to foresee those issues now? We're not going to have that much leverage over Holden in 10 years' time, are we?
I think that's a fair concern to have. It's hard to know what arrangements they're going to put in place to comply with their ongoing obligations under the consumer guarantee. But I understand the nature of the concern.
So if perhaps you can provide us some information about the nature of the consumer guarantee, looking that far out, both in terms of the product that people have purchased, but also the safety issues. I'd be keen to know how far out that liability stretches. Just a notice will be fine. And thank you for letting me interrupt you, Senator Farrell.
It's always a pleasure, Chair. Just on that topic of guarantees, what kinds of guarantees do you believe General Motors should be giving their customers, given that they were still selling vehicles up to and after the February 17th announcement of the brand withdrawal?
Oh, well, certainly the guarantees that we would refer to would be the ones that are in the Australian consumer law. So we would expect, as any supplier manufacturer of goods, that they would guarantee the goods are of an acceptable quality, fit for purpose, and free from defects, safe and durable. They're the consumer guarantees all suppliers have to meet, and they're the ones that we expect General Motors Holden to also abide by. And then there's also the guarantee as to repairs and spare parts, which is the specific guarantee we were just speaking about. Now those guarantees have remedies attached to them if there is a failure to meet them, and so we would expect that they abide by those guarantees, and that if they fail, the products fail with respect to those guarantees, that they provide remedies in accordance with the Australian consumer law to consumers.
Okay. The ACCC says that it's taken enforcement action against General Motors in the past for unconscionable conduct and misrepresenting the availability of the consumer guarantee rights. Can you give us a bit more detail and explanation of what you've done there?
I'll see if my colleague, Mr. Hees, can recall that specific action. If not, we may just have to take the details of that notice.
Sorry, I would just, so the ACCC has conducted a number of investigations in relation to allegations that motor vehicle manufacturers have engaged in unconscionable conduct in the provision of consumer guarantee services for consumers. The action that we took in relation to Holden or GM Holden was concluded in August of 2017 by the way of a court enforceable undertaking that the ACCC accepted from GM Holden, and primarily the concerns related to issues raised by consumers with the ACCC and other consumer law regulators that General Motors Holden wasn't repairing vehicles or providing them with a remedy in accordance with the consumer guarantees, which, depending on the extent of the fault, could be a refund or some form of compensation or restoring the vehicle to a reasonable standard. So that was the context of our investigation. And I would note we'd taken similar investigations and court or enforcement action against other manufacturers around the same time.
All right, thank you for that. There will no longer be a financial incentive for General Motors to look after its customers as they no longer plan to sell the Holden vehicle in Australia. How will customers be able to enforce their rights for General Motors after the brand exits from Australia a bit later this year?
I mean, we understand that there will be a local entity that will remain, and I assume it's the entity that the dealers that enter into the service agreement have contracted with, and we expect that would be the entity that would be ultimately responsible for consumer guarantee issues. So that is our understanding.
Right. What's the name of that entity? Do you know?
I'd have to take that on notice, unless Nick Keys knows.
I think we'll take that on notice, Senator.
All right, thank you very much. That's all my questions for the moment, Chair.
Senator McGrath, did you have anything else?
One quick question. In terms of
I have some
your...
questions as well.
Sorry, Senator Faruqi, I had known you were there. I think if Senator McGrath's only got one, I'll then let you see the question out. My apologies.
Sure. No worries.
Your investigation into the conduct of General Motors, how long do you think it will take, and when will it be concluded by?
Let me preface my answer, Senator, by saying that these investigations are quite involved and complex, and often it's hard to really judge how long it'll take to obtain evidence from those that are alleged to have engaged in the conduct or third-party witnesses. But with that caveat, we're certainly giving this investigation the highest of priorities and expect to have, at this stage, a public outcome this year. So either proceedings or an announcement that we haven't found any actionable conduct, but we're certainly hoping to wrap up our investigation this year.
Okay, thank you. And one final one, I'm sorry, Senator Fricke. I just want to confirm, so General Motors, they are fully participating with your investigation?
They're definitely engaging with us, but we do have compulsory powers as well. So participation happens one way or another. If that helps answer your question.
It does. Thank you.
Senator Faruqi.
Thank you, Chair. I'm just trying to understand or clarify the role that ACCC has played or is playing in the negotiations between General Motors and the dealers. So could you just kind of clarify that for me?
Yes, Senator. We don't play a role or an official. We don't have a role in relation to the negotiations, the commercial negotiations. Our role is simply to ensure that there is compliance with the Competition and Consumer Act. So we will intervene if we perceive that there might be a breach of the law, and we sought to intervene earlier this year when we had apprehended that General Motors Holden may not have been engaging in good faith in relation to the mediation process. So we took action to ensure that there was compliance with that aspect of the law. But otherwise, we don't have a role, and nor is it our place to negotiate between commercial parties.
Yeah, sure. In a submission from Mr. Palmer, who also provided evidence earlier, he says that General Motors Holden told him numerous times that the offer made to him was not negotiable and that he was subject to unconscionable pressure to accept an unfair offer. I'm just wondering, have you heard these concerns from other franchisees as well?
Yes. We definitely have heard concerns of that nature from other franchisees, Senator.
And is that widespread? Those concerns, are they widespread in your view?
I understand that many of the Holden dealers were not happy about the offer of compensation and the total package. That is my understanding.
Many submissions also point to the fact that, in their view, that the amended franchise code for new car dealers does not really address the power imbalances between franchisors and franchisees. In your experience, does this amended code, is this effective in addressing those concerns?
There are definitely challenges in regulating the relationship between franchisees and franchisors. I understand that the code is currently under review, but I otherwise don't have any adequacy of the current code. I think it would be. I think the lack of any sort of binding dispute resolution process is certainly problematic. So that is something that certainly could assist, but that has its own issues, as I understand it. I'm not sure, Mr.
Sorry,
Senator. Please go ahead.
Now, I was just going to say, in your submission, you do encourage this committee to consider further policy development to improve the franchise code. So were you in particularly thinking about dispute resolution, or were there other things as well?
I think dispute resolution was one. We have advocated for stronger civil penalties in relation to all the provisions of the code. I think higher penalties does usually assist with compliance in our experience. So certainly that would be another area of development that we think could assist.
Mm-hmm. In a submission from the Motor Trades Association of Australia, they say that they viewed a copy of the agreement which is presented to dealers and that they have significant concerns about some clauses. And one of the clauses they emphasize is that the agreements between Holden and dealers are not franchising agreements. Does ACCC have similar concerns?
I think that we would have to just point to our current investigation and all potential matters that might be a breach of either the ACL or the Competition and Consumer Act would be reviewed during the course of that investigation. I probably can't comment any further on any specific allegation that might still be pending as part of our investigation.
Sure. Then I just have one last question, Chair. In your submission, you say that ACCC has had concerns that General Motors encouraged some dealers to make large financial investments without disclosing that Holden would be withdrawing from the Australian market. Is that something that's under investigation, or could you give us some more information on that?
Well, that's certainly one of the allegations levelled against General Motors. And I stress it's an allegation at this stage, not proven, of course, but that they had encouraged capital expenditure without disclosing or at a time that they knew that Holden would be withdrawing from the Australian market. So as I say, that's an allegation that we're aware of and we're looking into that.
And when is your investigation, when will it be completed?
Senator, so in consistent with the answer I gave previously, we expect to have it completed by the end of the year and a public outcome advised before the end of the year. But noting, of course, complex investigations are uncertain in terms of how quickly we can obtain evidence and progress our investigation. But at this stage, we are prioritising this investigation and hoping to have it completed before the end of the calendar year.
Thank you.
Thank you very much, Senator Faruqi. Did you have any further questions, Senator McGrath?
No, I'm all good, thank you.
No, that's excellent. I had some, but I think I'll put them on notice in relation to the motor vehicle repair and service information. I think they can be dealt with that way. So I'd like to thank very much the ACCC for coming in to join us this afternoon for this hearing, and I'm sure we will be in touch again in the course of the inquiry.
Thank you.